Welcome to Ballantine Law, clear, practical legal advice that works. So, Alicia, if I told you that there's a single clause in many commercial leases that might cost a business owner tens of thousands of dollars and most of them haven't even read it, would you believe me?
Absolutely, I've seen it. People sign a lease that looks completely standard, run their business for 5 years, and then have a surprise at the end when they go to leave.
Well, that's what we're here talking about today, what a standard lease is and why people really need to understand what's involved. So let's start with the big myth. An agent comes over, hands a standard lease to you and says, don't worry, it's our standard commercial lease. What's wrong with that?
Well, standard means standard for the landlord. It means it's their precedent that they use. Maybe it's what their lawyers use. Maybe it's what the agent uses. It doesn't necessarily mean it's tailored to you, and it's there to protect the landlord. So it's important to have a look at those provisions.
It's fair to say most, or pretty much all leases, commercial leases, are prepared by the landlord, and it makes sense then that the landlord's going to, where possible, favour their own interests.
Of course, and these documents are so long, you often just get lost in the operative clauses. You sort of pay attention to the first bit where it sets out the key terms, and the rest can get a bit lost.
So they look at the schedule, see what they're paying each month, so that's fine. We're pretty happy with it.
Hope for the best.
So the takeaway is that standard really doesn't mean standard. It means this is the base that we're negotiating from.
Yeah, absolutely. If you've already agreed on the key terms, those will generally stay. It's hard to move on the key financials of it, but those standard operating clauses can always be negotiated on.
Okay, so the big clause that I was talking about at the start, which refers to the make good clause. What are make good clauses?
Make good clauses are all about the condition that you leave the premises in when you vacate, so at the end of your term. Make good obligations can include a really broad range of things. Things are really standard, like cleaning the premises, removing your items from the premises, making it free of rubbish, but can extend beyond that to reflooring the floors, repainting the walls, even replacing all of the light bulbs. It can be a really broad range of obligations.
And that's why we're talking about potentially big numbers, because it's the end of the lease, you think you're just going to move out, but there's actually a fair few obligations that are hidden in the lease that might cost you a bit of money.
Well, ripping out a fit out can cost just as much as getting the fit out installed. So it's important to consider your entering costs, but of course your exit costs, and it's difficult to expect what your cash flow is going to be like at the time that you're paying those exit costs.
Okay, so what can business owners actually do about this? What are some good ideas, not just in the lease, but that they could do practically to reduce the potential significant costs?
Practically speaking, you want to be taking documented photos when you take possession of the premises, so that if there's ever an argument of what condition you receive the premises in, you can then refer back to those photos. You can potentially negotiate. Obviously, if you want to take your fit out to wherever you're going next, that's fine. That can be costly. You might want to see whether the landlord is minded to retain some of your fit out. You might offer them to keep it because it might be a good marketing aspect for leasing the premises to the next tenant.
Because a lot of type of businesses, you're going to have a new business coming in of the same type, and they're going to potentially be able to use that fit out without them having to spend money on a new fit out, you having to remove.
Could be a bonus for the landlord to offer to a new tenant,
And I guess budgeting for it is a good idea too, to actually understand that at the end of the lease there may be a significant cost, and you really should start thinking about that from a cash flow and budgeting perspective from the start.
Yeah, absolutely.
So rent's the number most tenants primarily focus on, but you're always telling our clients that rent's only half the number. What do you mean?
Well, rent obviously is that fixed amount at the start, which then later is reviewed. Outgoings are also a key cost and can really add up. You need to be looking at whether the lease requires you to pay the outgoings, and that can extend, depending on the lease, rates, water and sewage access charges, land tax, body corporate fees, landlord's insurance costs. It can pretty much cover any cost associated with the landlord being the owner of those premises. So it can certainly add up. It's important to have an accurate estimate of those outgoings going into it if you are paying them, and also some sort of understanding of how those outgoings might change through the term of the lease.
Some leases that we see, we have landlords kind of putting in what would typically be a capital cost, so repairing roofs or installing new flooring. Those capital costs add value to the property,
Yeah.
those presumably, so it's not a bad argument for a tenant to say, well, no, you're paying for those because it improves the value of your asset.
Yeah, certainly. A key provision that can be negotiated of what costs are going to be the tenant's responsibility. And we typically see it's reasonable for a tenant to be responsible for any works that need to be done in connection with their use of the premises.
Their own fit outs.
Yeah, that makes sense. But when we're talking about just improvements to the premises as a whole, an argument can be made that the landlord should carry those costs.
Okay. Rents for the first year rarely remain the same for the second year unless you're negotiating a thing. So we have what we call rent reviews in place. What are some of the typical ways landlords look at changing the rent or reviewing the rent from year to year?
Well, there's three key mechanisms. That would be the fixed percentage. So you're told at the start the rent is going to increase by 3, 4, 5%, whatever it might be. The lower the better for the tenant. You can have CPI reviews where it's reviewed with reference to the most recently published CPI rates, which is a bit of an unknown for the tenant.
Particularly in recent years where we've had significant levels of inflation and changing rates, so it can be a little bit uncertain.
Yeah, certainly. And then you also have market reviews of rent, which we would typically see that come into play where you've exercised an option. So say you've had an initial 5 years, you exercise an option for a further 5, the landlord will want to do a market review before that's further term.
So there's often a couple of bases for rent reviews. During the actual term, you might have a fixed percent or a CPI.
Yeah.
And then if you want to roll over into a new term or exercise the option, it typically would be to market or what you agree with the landlord.
Yeah, and it makes sense. I mean, it creates uncertainty, but if you've been in a premises for 5 years, the market will have changed significantly and the rent reviews might not have kept up with that, or the rent reviews might have gone well over that. And that's an important thing to consider as well, is that the market rent might actually be less than what you're paying at that point in time if you've suffered a few rent reviews during the term.
Yeah, really a fixed percentage increase gives the tenant some certainty, but you're really gambling that fixed percentage is going to be better than a CPI or even a potential market.
Yes.
What's the ratchet trap that I hear people talking about?
Well, generally speaking, the landlord won't want the rent to go backwards. They're always going to want it to increase or at the very least stay the same. So if you get to renewing your options and you renew the option, they review it to market, they discover the market rent is actually less than what you're paying, they'll usually have included a provision that means that the rent will be just the same. It won't go down.
You get the downside of the market going up, but not the benefit of the market falling.
Exactly, yes.
So let's say I've rented a premises, and you've mentioned this term before. What is an option? I've rented a premises, I want to stay there. I'm not sure if the business is going to go over the next few years, so I say I'm going to give it 3 years. But I also want to be able to stay on for a longer period if the business is going well. How do I do that?
Well, that's exactly what an option is for. So, and options are advantageous for a tenant, but also for a landlord. It gives them security of knowing they're going to have what is hopefully a good tenant for them in for the long term, maybe. But the initial term of the lease, once that ends, if you have an option to renew, you can exercise that option, and provided you haven't been in breach of the lease, the landlord will be required to offer you a further term for the option period. So say you have a 5-year option, you receive a further term of 5 years.
So it's like a whole new lease from that 5-year period.
It's like an extension of the current lease because it's on the same key commercial terms for the most part. Sometimes it can be signing a new lease. Some landlords prefer to record it that way, but it can just be an extension of the current one.
But if you don't have an option, then there's no guarantees the landlord's going to rent the property to you again.
No, unless you sign a new lease with them, the tenancy will operate under holding over provision. So if you keep occupying the premises, the landlord has to agree to you doing so, but they haven't signed a new lease. It's just a month-to-month tenancy.
Let's say I decide I'm going to sell the business. The location is really important to the business. How do I deal with that as a tenant?
Under the lease, you'll be required to get the consent of the landlord to what we call an assignment of the lease, and that's basically you transferring your rights as lessee to your buyer so that they take over the lease when you sell them the business.
Does a landlord have to agree to that?
No, they have to act reasonably is usually the obligation, and it depends which legislation the lease falls under as the exact requirement, but usually the lease will set out that they have to act reasonably, but they can consider the financial standing and the business experience of the proposed.
So they're allowed to sort of to say, well, I want to assess this person just like I assessed you at the start of this lease to make sure that you're an
they don't have to
appropriate
agree
person,
to
you know
anybody.
how to run a business. And then there's clauses in the lease that turn what could be a company problem into a personal one? What does that mean?
Yeah, so we often see if you're leasing through a company or a trust entity, the landlord will often require the directors of your company, one or all of them or more, or even people outside of your entity, but often the directors, to provide a personal guarantee. And what that means is you, in your personal capacity, are guaranteeing the obligations of the tenant under the lease. So if your company fails to fill those obligations, such as paying rent being probably the most important one, then the landlord can pursue you personally for their losses.
So even though you have perhaps the asset protection of a company, the directors of the company may still have personal liability because they've promised that the company's going to meet its obligations.
Yeah, and that includes their personal assets as well.
Personal guarantee is different to a bank guarantee or a bond, isn't it? Many leases ask for both or a combination of the two. What's a security deposit or a bank guarantee or a cash deposit? How does that differ from a personal guarantee?
Yeah, well, the personal guarantee is usually unlimited. So it's as much as the landlord is owed by the tenant and as much damage as they've suffered by the tenant, they can come after you personally. The bank guarantee or a cash bond, and it's usually one or the other, is a fixed amount, and it usually increases with the rent as well. It's a fixed amount of funds that the landlord can call on to fulfill those obligations.
So they actually have those monies, they're sitting in an account.
Or they have the physical bank
guarantee. Promise to pay those things, but there's money behind it.
Yes, and they can call on that. Say, for example, you vacate the premises and you've left it in a state, they can call on that to bring the premises back into the condition you were meant to leave them in.
So let's say someone has received a lease, they want to sign, they want to get into the property. What should they do?
Well, they should definitely be coming to see us and to have it reviewed. We do a very thorough review, calling out key provisions that they should consider, making recommendations, and then we can action your instructions following receipt of that review as well and act for you in negotiating with the landlord, whether it's their lawyer or their agent that we're negotiating with, to hopefully get you a better outcome than what you've been presented with. We usually at least see some movement from these landlords.
Because sometimes it's the key commercial terms have already been agreed. How much rent, how long you're going to be in there. But it's those hidden provisions that people really need to understand and might negotiate before they sign the lease.
Yeah.
For more legal insights, subscribe or visit ballantinelaw.com. We're here to help.